हाँ भाई, तो लास्ट क्लास में अपन ने ये डिस्कशन किया हुआ था कि आर्टिकल 16 क्या कहता है। आर्टिकल 16 सेज दैट Article 14 to 16 talks about right to equality, and we have discussed Article 14 and Article 15 as well. Now we have already discussed Article 16, where we have discussed equality of opportunity in matter of public employment. In Article 16, one says that equality of opportunity in public employment or any appointment by the government. For example, we have discussed reservation in government job in Article 16(2). It states that no discrimination against any citizen with respect to government job on the basis of caste, sex, race, religion, place of birth, residence. What do we mean by residence and place of birth? Basically, residence or citizen. Basically, residence is known as you are living in India, you have acquired citizenship of India, and your intention is also to live in the India. But you are living in India. If your intention is not to live in India, then it is not a resident. So that is the basically definition of residence. Now we have discussed Article 16(2) that state no discrimination against any citizen with respect to government job on the basis of race, caste, sex, decency, place of birth, etc., and any of them. And Article 16(3) is the exception to Article 16(2). Basically, it says Parliament can discriminate on the basis of to on Parliament can discriminate to citizens of another states while giving the government job in particular another states. Basically, it state अगर एमपी में कोई वैकेंसी है और अगर यूपी के बच्चे उसमें अप्लाई करते हैं तो स्टेट पार्लियामेंट कैन डिस्क्रिमिनेट एंड कैन मेक लॉ to prohibit UP students to apply in the MP government job. So it can be done only by the parliament. Now, Article 16(4) says that state can reserve a seat in government job for backward classes citizens if they are not adequately represented. So state can also it is also exception to Article 16(2) basically that state can discriminate or state can give reservation in the government job for the backward class peoples. Now we have also discussed Article 16(5) that by law that prescribe that people belonging to particular religion only shall hold office in connection with the affair of religious. So basically states that if Hindu religion institution and for the appointment of any person for the Hindu religious institution, then state can make law that on that post only Hindu people will be appointed or will give opportunity in that post. Let us suppose if it is the Muslim or Muslim institution, then the Muslim people should get the opportunity on that post. So that's the basically can be done by the law. Now we have discussed Article 16(1), 16(2), 16(3), 16(4), 65. Now we have discussed the evolution of reservation, how the reservation has been brought in the India. So I have told you at the time of 1950, reservation has been provided to the SC and ST community in the Lok Sabha and the state legislature, not in the legislative council, only legislative assembly. LA on the basis of share of their population, and also uh, reservation in the government job has been provided to the SC and ST communities, to the central government job and the state government job, and also reservation has been provided. No reservation has been given to the educational institution for the SC and ST community for the central university. In state university, reservation has been given to the SC and ST communities. So this is the situation at the time of 1950. Now, in the case of Champakam Dorai Rajan versus State of Madras, so what is the basic context of that? That 1920 in 1920, there is a huge communal violence against the Brahman community. Therefore, state had made and give the reservation to the backward class by simply a communal order. Therefore, now it's violate fundamental right under Article 14, 15, 29C. So in this case, Supreme Court stated, and in this case, state government says that they are implementing Article 46, where he says that while we are objecting some criteria of DPSP by overruling the fundamental right. So in the Supreme Court stated that this communal order is unconstitutional, therefore it should not be exist. So now this criteria has been happened. Then in contrast to this, because Supreme Court has given the judgment that it is unconstitutional, so Parliament passed the first Constitutional Amendment Act and added Article 15(4) in the Indian Constitution, and state where state has where what has state been done? State can make provisions for advancement of SC and ST and backward class people. So basically here what he had done, they have also provided the reservation for the backward class. So now reservation can be given to the SC and ST community and also to the backward class. So what the situation after the first constitutional amendment act? So basically in the educational institution, reservation has also been given to the backward class, to the SC and ST community by the first constitutional amendment. And in the reservation in assembly, there is no change, because there is no change, that is, reservation has been given in the Lok Sabha and in the legislative assembly. And in the government job, no change, that is same as. But in contrast to this, government has also made a commission, that is Mandal Commission. What the work has been assigned to this Mandal Commission? Basically, Mandal Commission has to examine the backwardness class other than SC industry. First, the work has been assigned to him. The second work assigned to him, that you should be laying down the criteria on what basis you have uh, identified the backward class. Third criteria, give recommendation for the upliftment of the backward class of the society. So on the first question, they told that approximately 52% people are backward class, and so therefore backward class, and what you should then, you should provide 27% reservation to the SC, to the backward class citizen. Why 27%? Because Supreme in the one judgment, MR Balaji versus State of Mysore, Supreme Court already stated that reservation cannot breach the limit of 50%. So you have already given 22% reservation to ST communities. So therefore, only 27% reservation has been left. So you should give it to the backward class citizen. Now, what is the criteria for identification of backward class? So basically, Mandal Commission, what has been done? Mandal Commission has made a 12 indicator. 4 indicator are social indicator, educational indicator, economically indicator, and on the basis of these indicator, they said that 55% persons are OBC, and one indicator is one of them is caste. So basically, out of 12 indicator, there is one indicator that is caste. So now, in contrast to this, Mandal Commission, government issued a order and give 27% reservation to the OBC, and also they give 10% reservation to the economically backward class. So basically they have also given, so in contrast to this judgment, a court has been filed in the Supreme Court in the name of Indra Sahani versus Union of India. So in Indra Sahani case, what the questions has been arises in the Supreme Court. First question has been arises that is reservation violate the principle of inequality? No. Supreme Court says no, it can't violate because it is made for the upliftment of the marginalized section, of the discriminated section. So it's not violating the principle of equality, because I have already discussed in Indian form of inequality is not basically same as the treating equals to equals, treating equal. Basically, who are equal, then it is okay, but who are not unequal, then you should not treat him as a equal, because they should also be treated as unequal. If you are not treating him unequal, basically if you're not providing him any extra provisions to uplift them, then basically they will always be unequal. So basically, in response to this question, Supreme Court says no, reservation is not a discriminatory. Basically, government can provide extra advantage to the marginalized section. And second question has been asked that is executive order is enough for the giving reservation? Supreme Court says yes, because it giving effect to the Article 16(4) of the Constitution of India. So it can be done by only the executive order. And another question has been asked, are reservation are anti-merit? So again, Supreme Court says no, reservation are not in anti-merit. And they have also asked that can 50% limit breach? So Supreme Court said no, 50% limit cannot be breached. And another question, 10% to EBC, मतलब economically backward class is violations. Supreme Court says yes, reservation cannot be done only the basis of economy. And our caste-based reservation is valid. Supreme Court says caste, this reservation is not only on the basis of caste. Basically, caste has used as one criteria for determining the backwardness of the class. So basically, on the basis completely saying it is based on the caste, that is not okay. But one question has also been asked, can reservation in promotion is also valid? Supreme Court, no. Reservation is in the promotion is not okay because it will lead to the egoistic approach within the department. So reservation should not be given in the promotion. Another questions, much more questions has been asked that should reservation within the community will be okay? So Supreme Court says uh, state government should ensure that within the community, let's suppose within the SC and the ST communities, there are many people who are already advanced. So you should not give reservation to them. So you should make a criteria so that within the SC and ST community, within the OBC community who are backward, they can only get the reservation benefit. Now, in contrast to this judgment, Parliament passed 77th Constitutional Amendment Act and added Article 16(4)(a). They basically says they have also give reservation in government job, but they've also extended reservation in promotion. Basically, they've also extended in reservation for the promotion as well. The Parliament also passed 81st Constitutional Amendment Act, where they added Article 16(4)(b). That is, they stated that reservation can be carry forwarded vacancy in the next year, and they have also added 82nd Constitutional Amendment Act, where they added article provision to Article 360, 335, that is allows relaxation in the merit marks in promotion. And 85th Constitutional Amendment has also been added, where they added consequential seniority to Article 16(4). We have discussed what is the consequential seniority. Then after, in contrast to these all has been challenged in the M. Nagaraj versus Union of India, where Supreme Court upheld all the Constitutional Amendment Act as a valid because they are all okay. But Supreme Court also stated reservations are not a fundamental right, therefore they can't be challenged in the Supreme Court. And government also ensure that while giving the reservation, you should have adequately sufficient data for the backwardness of any class and have a quantifiable data to representing backwardness of any section. In the Journal Singh vs. Union of India, Supreme Court reiterated its judgment and said that you don't need to produce quantifiable data for representing backwardness of any society. So basically, but now in 2019, 2019, 109th constitutional amendment has been passed, and in this amendment, Parliament added Article 15(6) and Article 16(6). Basically, what they have said reservation has been given purely on the basis of economic criteria, that is 10% reservation to EWS has been given. This is contrast to Indra Sahni judgment, and therefore this has been challenged in Janhit Abhiyan versus Union of India. So Supreme Court said that 10% reservation on the economic criteria is okay, is valid, plus executive order is enough to give reservation in India. So that has been discussed till now. We have discussed. Now let's move on to the Article 17 of the Constitution of India. So we have discussed Article 16 in detail, and we have also discussed Article reservation policies, reservation evolution of reservation in India. Now let's discuss Article 17 of the Constitution. What the Article 17 says, let's discuss once. No, Article 17. Once read Article 17, then we will move forward. Sure. So let's read Article 17 first, then we will discuss more on it. So Article 17 talks about abolition of untouchability. Basically, abolition of untouchability. There should no there will no the practice of untouchability will not be continued in India. So basically, untouchability practice will be completely abolished by Constitution of India. You don't interpret basically untouchability on the basis of simply saying on touching basis. No. Supreme Court of India has provided and expanded the untouchability definition in various aspects. So basically, untouchability means cannot practice in any form. So basically, what is the untouchability practice? Basically, it is discriminating practice, discriminating practice by not touching or hating to any person on basis of birth of that person. So basically, if you have born in the in the particular community on the basis of their birth, this practice has been followed that uh, I will hate you or I will not touch you. This practice cannot be continued in the in India. So basically, Indian Constitution has completely abolished it. So in the Sabrimala case, what Supreme Court says in the Sabrimala case, Supreme Court stated that the practice of not allowing the women between 10 to 15 years who are in their maturation age is also be considered as untouchability practice, so it cannot be continued. So basically, in Sabrimala case, Supreme Court stated that not allowing women between 10 to 15-year-old who are in their menstruational age will also be a practice of untouchability. Therefore, it cannot be continued. Therefore, it can't be continued. So basically, we should allow the 10 to 15-year-old women to enter in the centum centorum of the temple. Therefore, allow 10 to 15-year women in centum centorum of the temple. Now, in another case, Safai Karmachari Andolan versus Union of India, Supreme Court stated that manual scavenging is also a part of untouchability. So basically, because in रियलिटी में अगर आप देखेंगे ना तो मैनुअल एक्सकैवेटिंग केवल और केवल दलित समाज के द्वारा किया जाता है, एससी और एसटी कम्युनिटीज के द्वारा किया जाता है. कोई भी ब्राह्मण कम्युनिटी ये काम नहीं करती है. तो सुप्रीम कोर्ट स्टेटेड दैट मैनुअल एक्सकैवेटिंग ओनली बाय एससी एंड एसटी कम्युनिटी, व्हाई इट शुड बी डन. It is also a part of untouchability. It also considered untouchability. Why only some people who are belonging to some particular class should be do the manual scavenging? Why any particular class? So there should be a proper rule and procedures which should be established. Now, in another case, so basically, the Supreme Court extended the definition of this, and in another case, Supreme Court also said imposing disability on the basis of untouchability, imposing disability on basis of untouchability is also an offense. So basically, if you are imposing any disability to any person on the basis of their untouchability criteria, then it will also be considered as an offense. Is that clear to you? Now, if it has been considered as offense, then what criminal procedures will be followed on that person? So basically, it will be decided only by parliamentary law. State law cannot define what procedure or what uh, prison should be given to that particular person. So basically, punishment will be decided by parliamentary law. Now, is that clear? Now, because of this, which has been given in the Article 17 of our Indian Constitution, Parliament passes a law which has been called as Abolition of Untouchability Act. Abolition of Untouchability Act 2000 1955. So basically, Parliament passed this act, and on behalf of this act, what the Parliament stated, and also now it has been transferred into Civil Right Act. It renamed as Civil Right Act 1976. What according to this, even promoting and advocating untouchability is also an offense. Basically, it states that according to this act, which has been passed by the parliament, according to this, even if you are promoting, if you are discussing that this untouchability practice is good, then it will also be considered as an offense. And if any lawyer advocating in favor of untouchability, then it will also be considered as offense. Now, in this act, the parliament also stated that justifying untouchability untouchability on the basis of ancient on historically ground on historically ground is also an offense. So basically, if you are justifying untouchability on the basis of ancient culture, on the basis of such documents, then it will also be considered as an offense. Now, Supreme Court also said that, Parliament also said that prohibition to access, prohibiting to access to temple on basis of caste is also offense. And they also stated boycott of family on basis of caste will also be considered as offense, is also offense. So basically, Parliament enacted the Civil Rights Act, and they have stated that promoting and advocating untouchability is also an offense. Justifying untouchability on the historically ground is also an offense. Prohibiting to access to any temple on the basis of caste is also an offense. Boycotting a family on the basis of their caste is also an offense. Now, we have discussed Article 17, where it talks about abolition of untouchability. You can't practice untouchability. Basically, in Sabrimala case, Supreme Court stated that prohibiting for entering in the sanctum sanctorum of temple between to the girls between 10 to 15 years is also a practice of untouchability. Therefore, remove it. In uh, Safai Karmachari Andolan, was Union of India, Supreme Court stated that manual scavenging is also a part of untouchability. Therefore, it cannot be continued. And according to this, Parliament passed an act which is Abolition of Untouchability Act. Now it is called as Civil Right Act. According to this act, promoting and advocating untouchability is also an offense. Justifying untouchability on historically ground is also an offense. Even boycotting a family on the basis of caste is also an offense, and prohibiting to access to any temple in on the basis of caste is also be considered as an offense. Now, what are the implications if you have violated this practice? Basically, if you follow the practice of untouchability, then what will be the implications on you? So basically, implications, prison, imprisonment can be happen, or fine can be charged, or both. And what can be other grounds? Disqualifying for contesting the election, for contesting election for 6 years, and it is cognizable offense. Therefore, police can arrest even without warrant. And untouchable, if you violated the untouchability practice, then Supreme Court stated that your guilt will be considered as true. Now you have to prove you have not done it. Basically, if any person goes to Supreme Court and said that they have practiced the untouchability against me, then let's suppose I am the person who belonging to Brahman community, and there is another person who is belonging to from SC and ST community, and this person has goes to Supreme Court and said against to me that I am the person who have not followed, who is violating untouchability practice, basically following the untouchability practice. Then now it's my duty to argue in the court and prove that I have not followed, because Supreme Court has already assumed that you have done guilt. Basically, I have followed. Now it's my duty to prove in the court that I have not followed the untouchability practice. So these are the basically implications which has been given in the Article 17 of the Constitution of India. Now let's move Article 18 of the Constitution of India. So what the Article 18 says, let's read first, then we will discuss on it. What the Article 18 says that abolition of title. Basically, it talks about abolished abolition of title. Now let's discuss what do we mean by this fundamental concept. Now, let's discuss about the Article 18. Basically, it talks about abolition of title. Okay, so let's read first. No title not being a military or academic, no title not being a military or academic distinction shall be conferred by state. So basically, first we understand what do we mean by title. What do we mean by title? Basically, title is the prefix or suffix which has been used by the person to use it before the name or after the name. So basically, it is the prefix or suffix to one's name. आपने सुना होगा कोई कहता है नंबरदार, या जो ब्रिटिश के द्वारा दिए गए टाइटल्स हुआ करते थे तो वो अभी भी कहीं कहीं यूज होते हैं, अपना रैंडम के लिए यूज कर लेते हैं, लेकिन ये प्रोहिबिट है. It cannot be practiced along right now. So now this is the basically title. What is the why? Because why this title has been assigned? Because to create prestige class in this society which loyal to British government. So basically the purpose of title is this. What is title? This. No. Constitution of India is completely prohibited the using as a title in the prefix or in the suffix. Now, let's read first Article 18.1. Then we will discuss first another provision. So, Article 18.1 says that no title not being a military or academic distinction shall be conferred by state. So, basically, it states that state cannot award any title. State can't award any title, but state can award the title only to military personality and also to academic personality. Exceptions are these. So basically, Article 18.1 says that state cannot award any title to any citizen of India except the military personality, except the academic personality. You have seen that in the President awarded the Padma Shri award, President awarded the Ashok Chakra for the various distinction in the military purpose, and the the for if you're doing the PhD degree, then then doctor prefix has been allotted to you, then you can use the name, you can use the doctor before your name. So these are exceptions to Article 18.1. So basically, Article 18.1 talks about you can't, state can't award any title to any citizen except military or except academic personality. Now, let's read Article 18.2. Article 18.2 talks about what the Article 18.2 says. Article 18.2 says that no citizen of India shall accept any title from any foreign state. So it states that no citizen of India can accept title from foreign state. So basically, Article 18.1 limits the power of state while saying state can't award title to any citizen. And Article 18.2 says that citizens cannot accept any title from the foreign state. Now, let's read Article 18.3. We have discussed Article 18.1, Article 18.2. Now, discuss Article 18.3. Article 18.3 says that no person who is not a citizen of India shall, while holding any office of profit or trust under the state, except without the consent of President of India from any foreign state. So basically, Article 18.3 says that any foreign citizen, so any foreign citizen who holding a post of office of profit or trust in India cannot accept any title from foreign state without consent of president. So basically it imposes the limit on the foreign citizen. If there is any foreign citizen who is working in India and hold a post which is a post of office of profit or a trust, then that person cannot accept any title from the any foreign state without the consent of President of India in India. है ना? These the basically Article 30 18.3 talks about. Now let's read Article 18.4 of the Constitution of India. What the Article 18.4 says that. So Article 18.4 says that no person holding any office of profit or trust under the state shall, without the consent of President, accept any present emolument or office of any kind from or under any foreign state. So basically it says no person without consent of president shall accept any gift, office, emolument, etc. from a foreign state. Now it should be clear to you. Article 18.1 says that state cannot award any title except military personality, except academic personality. 18.2 says that no citizen of India can accept any title from the foreign state. Article 18.3 says that if any person which is belonging from the foreign states are working in India and hold office of profit or any trust in India can't accept any title from the foreign state without the consent of President of India. Now, Article 18.3 we have discussed. Article 18.4 we have discussed that no person in India can accept any gift, any emolument, or any type of gift from the foreign state without the consent of President of India. Now, what about the Padma Shri Award and what about the Bharat Ratna Award? So basically, we have discussed all the award. We have discussed Article 18. Now, what about the Padma Award? What about the Padma Vibhushan? These type of title. So basically, what about civilian award? That is Bharat Ratna or Padma Award. So basically, in case of Balaji Raghavan versus Union of India, Supreme Court stated that Supreme Court held that civilian award are not considered as title. Basically, civilian award cannot be considered as title, but court also stated this award cannot be used, stated that award can't be used as prefix or suffix to the name. So this has been stated in by the Supreme Court. So basically, Supreme Court stated in the Balaji Raghavan case that these awards are not the title, but if you are using this award as a prefix or suffix, then it is not be used. If you are using, then it can be taken away from you. So basically, Padma Shri award can be taken away if you are using as a title. But many persons used and they shows that they have won, they have get the Padma Shri award. But according to Constitution, according to Supreme Court judgment, they can't be used. If you will file the petition in the Supreme Court, then it can be a possibility that it can be taken away from that person if that person using it as a title. Now, okay, I think it will be clear. एंड ऑल्सो सुप्रीम कोर्ट स्टेटेड, आपने देखा होगा कि भाई ये पद्मश्री अवार्ड और भारत रत्न अवार्ड किसी को भी मिल जाता है, जिसको कुछ भी नहीं आता उसको भी मिल जाता है, कुछ भी नहीं आता, घंटा एक्टिंग किसी को नहीं आती, लेकिन वो पद्मश्री लेकर बैठे हैं। क्यों? क्योंकि वो एक्टर की दुनिया में, उनके पास पैसा है, उन्होंने अवार्ड को खरीद लिया है। बहुत से ऐसे पर्सन्स हैं जिन्होंने घंटा कुछ नहीं किया, लेकिन उनके पास पद्मश्री अवार्ड है। बहुत सारे एक्टर्स ऐसे हैं जिनको घंटा एक्टिंग नहीं आती, वो तो फैमिली बैकग्राउंड के तहत मिल गई उनको एक्टिंग का एक इंडस्ट्री, लेकिन एक्टिंग तो उनको आती नहीं है, लेकिन वो भी पद्मश्री लेकर बैठे हैं। क्यों? क्योंकि आजकल आप पद्मश्री और अवार्ड खरीद सकते हैं। तो फॉर दिस सुप्रीम कोर्ट ऑल्सो स्टेटेड टू गवर्नमेंट एंड डायरेक्टेड टू गवर्नमेंट that you should maintain respect of award, not by distributing arbitrary, आओ भैया तुम भी ले लो, आओ भैया तुम भी ले लो, ऐसा नहीं करना है। If you have at least maintained the respect of these award while giving to any person, you should check that this person is eligible or not. So basically, how this can be maintained? By making a committee to examine whether this person is eligible or not. Eligible or not. And this committee should be chaired by Prime Minister. Now it should be okay. Now we have done with the Article 18 of the Constitution of India. Now let's move Article 19. So we have done Article 14 to 18, which talks about right to equality, and where we have discussed about Article 14, which is discussed equality before protection, equality before law, and equality before protection of law. and we have discussed those both concept, equality before law and equal protection of law. Then we move Article 15. We have discussed Article 15, and now we have discussed Article 16 as well, and also we have discussed Article 17, 18 now. Now, Article 17 talks about abolition of untouchability. Article 18 talks about abolition of title. Article 16 talks about equality of opportunity in public employment. Article 15 talks about prohibition of discrimination on the basis of caste, sex, religion, place of birth. So we have discussed Article 14, equality before protection of law, equal protection of law, equality before law. Now we have discussed these all the articles. Basically, in the short form, Article 14 to 18. Article 14 talks about equality before law and equal protection of law. Article 15 talks about equal no discrimination on the basis of caste, sex, religion, and place of birth or any of them. Article 16 talks about basically reservation should be provided for the backward classes in the government job. And Article 17 talks about abolition of untouchability. Article 18 talks about abolition of title. So these are 14 to 18, which talks about right to equality. Now let's move right to freedom. So we have discussed this till now. Now let's move Article 19 of the Constitution of India. So Article 19, basically right to freedom. Here we will study Article 19 to 21. Now it should be okay. Okay, now let's move Article 19 first, then we will move further Article 20. So first read about Article 19 of the Constitution. Okay, so Article 19 talks about right to freedom. Let's read once. So Article 19 talks about protection of certain rights regarding freedom of speech. First, all citizens shall have the right. First, Article 19, First A, to freedom of speech and expression, to assemble peacefully and without arms, to form association or union or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of territory of India, and to practice any profession or to carry on any occupation, trade or business. Now, basically, Article 19 have six provisions. Article 19 first A, Article 19 first B, Article 19 first C, Article 19 first D, Article 19 first E, and Article 19 first F. So basically, these are the six provisions which has been provided Article 19 1A. So now Article 19(1)(a) says that every citizen of India have freedom of speech and expression. Article 19(1)(b) talks about right to assemble peacefully. And Article 19(1)(c) talks about to form association. So right to form association. Article 19(1)(d) talks about right to move in anywhere of territory of India. So Article 19(1)(d) talks about right to movement. Article 19(1)(e) talk about right to residence across India. Article 19(1)(f) talks about right to occupation, trade and business all across India. Right to occupation, trade, business across India. But remember one thing, these all rights are provided with certain conditions. Now, for the Article 19(1)(a), which talks about freedom of speech and expression, has been restricted by the Article 19(2). In Article 19(2). And Article 19(1)(b), which talks about right to assemble peacefully, is restricted by Article 19(3), and this has been restricted by Article 19(4). This has been restricted by Article 19(5), and this has been restricted by Article 19(6). Now it should be clear. Basically, 19(5) it talks about both. Okay. So in Article 19(1)(a), which talks about freedom of speech and expression, Article 19(1)(b), which talks about right to assemble anywhere, Article 19(1)(c), which talks about the right to form association, Article 19(1)(d), which talks about right to movement, Article 19(1)(d), which talks about right to residence all across the India, Article 19(1)(f), which talks about right to do business occupation in across India. And the restrictions ground for Article 19(1)(a) has been given in Article 19(2). Similarly, for 19(3), 19(4), 19(5), for both right to movement and right to reside across the India, and Article 19(6) provides the restriction ground for the Article 19(1)(f). Now, let's discuss one by one in detail. What do we mean by Article 19(1)(a)? Article 19(1)(a) talks about freedom of speech. Basically, it has been taken from the Irish Constitution. It talks about freedom of speech and expression. Now, once person can express themselves by speech, by written words, or by the various art form. On any form, freedom of speech and expression can be expressed by citizen by any of the form. It can, and Supreme Court also extended the definition of freedom of speech and expression, that expression can be extended to various gesture, look, sign, symbol, etc. So it can be, you can express yourself, you can also express yourself by the silence. So in whatever way, if you are expressing yourself, you have the freedom to express yourself by in whatever way you want. Now, it also include freedom of press. There are numerous cases which has been gone in the Supreme Court of India in the case of Sakal Paper versus Union of India, in Indian Express versus Union of India, in Bennett Catman versus Union of India. बेसिकली सुप्रीम हुआ क्या था कि सुप्रीम को गवर्नमेंट ने क्या काम किया कि गवर्नमेंट ने जो पेपर पब्लिश होते हैं इंडियन एक्सप्रेस के, उन पेपर्स पर लिमिट लगा दी कि यू कांट परचेज द पेपर मोर देन सच क्वांटिटी. So basically, if you are restricted to any news agency for purchasing the newspaper, then basically you are prohibiting him to express more news in the country, because earning for the news agencies has been from the advertising, not by the selling paper. So if you are prohibiting him to purchase the newspaper, then basically you are prohibiting him not to advertise and not to earn money. So you are restricting. Then Supreme Court stated that you can't do so. So basically you should allow to news agencies to purchase the paper as much as they want. So in these cases, Supreme Court allows that freedom of press is also a part of freedom of speech and expression. And in the Genova Witness case, plus Supreme Court also in the case of Genova Witness, what has happened? Let's discuss. एक स्टूडेंट था जो कि क्रिश्चियन कम्युनिटी को फॉलो करता था. तो क्रिश्चियन कम्युनिटी में एक रूल है कि आप अपने रिलीजियस एंथम के अलावा किसी और एंथम को नहीं गाएंगे. तो जब नेशनल एंथम हो रहा था, तो वो स्टूडेंट साइलेंट खड़ा रहा. उसने ना तो नेशनल एंथम का अपमान किया, केवल उसने गाया नहीं. तो ये केस पहुंचा सुप्रीम कोर्ट में कि भाई इस स्टूडेंट ने नेशनल एंथम का अपमान किया. दे हैव disrespected the national anthem. So in this case, Supreme Court stated that while not singing the national anthem, it should not be considered as disrespecting of the national anthem. So, right to remain silent will also be a part of freedom of speech and expression, and also right to vote in nota is also a part of freedom of speech and expression, and also right to know criminal background, right to know criminal background of your political leader, and also economic background of your political leader is also a freedom of speech and expression, and it also include right to communicate in modern means, basically by email, by calling, by chatting, etc. It also includes these. So therefore, this has been given power. This all the provisions has been included in the Constitution of India under the freedom of speech and expression. Basically, right to vote in nota, right to remain silent, right to form association, sorry, right to form, right to communicate in modern means of means, right to know criminal procedures, right to know criminal background of your political leader, right to know economic background of your political leader, right to remain silent, and right to freedom of press, and you express yourself in the form of various gesture, various art form, by dance, whatever way you want, you can express yourself, and also by words, by written, or by speaking. So you can express yourself by any form, whatever you form you want. Now it should be clear to you, I think. Now we have discussed Article 19 1A in detail, but these all rights which has been given under freedom of speech and expression all can be restricted on the ground, all can be restricted on the ground mentioned in Article 19.2. So let's read Article 19.2. Basically, Article 19.2 includes the ground on which Article 19.1a can be restricted. So Article 19.2 says that nothing in subclause A of clause 1, basically it talks about Article 19.1a. So nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law is so far as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of sovereignty and integrity, the security of the state, friendly relations with foreign state, public order, decency or morality, or in relation of contempt of court, defamation, incitement to an offense. So basically, it can be restricted on the basis of public order. We have discussed public order, sovereignty and integrity of India, and it can also be restricted on the decency or morality. It can also be restricted on the contempt of court, defamation, incitement to or to an offense. and friendly relation with foreign state, and security of state. Now public order has been removed. Now, these are the grounds on which your freedom of expression, speech and expression can be restricted. Okay, we will discuss in the next class. Till now, take the break.